Hi, today I will be presenting on intra-company transfer from Canada to Japan. Here is an overview of what I will cover today. First, I will explain the visa and work authorization required for intra-company transfers. Next, I will outline the application process, cost, and required documents. Then I will discuss validity periods, extension rules, and spouse work rights. After that, I will highlight legal limitations and compliance concerns employers must be aware of. Finally, I will summarize the key takeaways. The structure helps us understand the process step by step from application to working legally in Japan. Employees transferred from Canada to a Japanese branch must apply for an intra-company transfer visa, also known as ICT. This visa is issued by Japan's Immigration Services Agency and is specifically designed for employees who are moved within the same multinational company. One important requirement is that the employee must have worked for the overseas office for at least 1 year before the transfer. The Japanese company must sponsor the application, meaning employees cannot apply independently. Unlike some countries, Japan does not issue a separate work permit. Instead, authorization to work is granted through a legal status called a status of residence, which defines the type of work the person can perform while in Japan. Before a visa can be issued, the employer in Japan must apply for a certificate of eligibility, commonly called a COE. This document confirms that the employee meets immigration requirements. The government typically does not charge a fee for issuing the COE, but processing can take 1 to 3 months. After receiving the COE, the employee applies for the visa at the Japanese embassy. Visa fees generally range from about 30 to 50 Canadian dollars for single entry and around 60 to $70 for multiple entry visas. When the employee arrives in Japan, they also receive a residence card at no cost. It is always recommended to verify updated fees at the embassy because amounts may change. Several documents must be prepared for the visa application. For employees, this include a valid passport, visa application form, passport photos, the certificate of eligibility, employment contract, transfer letter from the Canadian company, proof of company registration in Japan, and evidence showing at least 1 year of prior work experience. For spouses or dependents, additional documents are required, such as marriage certificate, birth certificates for children, passports, photos, and their own dependent COE. Accurate documentation is extremely important because incomplete or incorrect paperwork is one of the most common reasons for visa delays or rejection. The intra-company transfer status is usually granted for 1, 3, or 5 years, depending on the employment contract and immigration assessment. The visa can be renewed as long as the employee remains employed in the same position and continues to meet requirements. There is no official maximum number of renewals. After several years, typically 5 or more, the employee may become eligible to apply for permanent residency or a highly skilled professional visa, depending on their qualifications and experience. This means that although the initial transfer is temporary, long term residency is possible if the individual meets immigration criteria. Spouses of transferred employees usually enter Japan under a dependent visa, also called family stay status. Under this visa, spouses are not automatically allowed to work. However, they may apply for special permission called permission to engage in activity other than that permitted. Once approved, they can work part time for up to 28 hours per week. If they want to work full time, they must apply for their own independent work visa. This is important for families to consider because it may affect financial planning and career decisions before relocating. Japan's immigration system recognizes legally married spouses, typically opposite sex couples, and sometimes same sex couples if their marriage is legally registered in their home country. However, recognition may vary depending on circumstances. Common law partners are generally not eligible for dependent visas, which can create challenges for international assignments. Although policies are gradually evolving, same sex marriage is not widely recognized in Japan, and immigration decision may be evaluated case by case. Employers should therefore carefully review family situations before arranging international transfers to avoid legal or personal complications. Employees must have relevant specialized skills, and immigration checks that their qualification match the job. The visa is tied to the sponsoring employer, so changing jobs requires approval. Some roles require Japanese language ability, and salaries must match local standards or the visa may be denied. While there are no strict quotas, authorities carefully review each transfer for legitimacy and compliance. To conclude, when a Canadian multinational company transfers an employee to Japan, the worker must obtain an intra company transfer visa and a certificate of eligibility. The visa is typically valid for 1 to 5 years and can be renewed. Spouses may work part time with permission, but common law partners may face restrictions. Employees must meet skill, salary, and employer sponsorship requirements. Although there are no strict quotas, immigration rules are detailed and compliance focused. Overall, Japan offers structured pathways for international mobility, but the process requires careful preparation, paper documentation. These are the sources used for this presentation. Thank you for listening.